Good afternoon, everybody. Thank you for joining me. My name is Ted McGinn. I'm the managing partner at Lavelle Law. And we have a great program for you today. Just so you know, Lavelle Law, we are a full service law firm. We have many different practice areas. We have offices in Schaumburg and downtown Chicago as well. So before I turn it over to my colleague, Steve Magala, you may be wondering, what has Lavelle Law been doing since this outbreak? Well, like any business, we've been adapting. We've been adjusting. At this point, we have enabled all of our attorneys to work remotely from home. They have access to all the client files. They have the ability to access email, take phone calls. So we're still up and running and operating. In addition, we've done a couple of different things to make our client experience better. First of all, in estate planning, we've been set up where now we can have remote estate planning signing of wills and trusts, doing that remotely. In addition, we've also had some real estate transactions been handled remotely as well. So we've adapted. We're still up and running. We're still operating. So today we have a great program. I want to turn it over to my colleague here, Steve Magala. Steve, take it away.
All right, thanks, Ted. I'm going to skip ahead here to this slide. So I just want to introduce our panel. First, you already heard from Ted. He's our managing partner. He does a lot with general corporate work and healthcare areas. We're all shareholders, by the way, too. I do a lot of corporate work, commercial real estate, as well as commercial lending and financing. Lance, another shareholder, he does a lot of litigation and employment law matters as well. And Josh does a lot of tax, corporate, and employment law. So I think we have a pretty good panel then for these topics. Let me jump back to our agenda over here. So here's our agenda. We have financing, deferring payments and funding off creditors, small business bankruptcy, and then just kind of a potpourri of employment law topics. So, it's a pretty broad agenda. So we're going to try to limit it to maybe 5-10 minutes, give or take, for each topic. And we do want to leave about 15 minutes or so for Q&A, because we know you guys probably have a lot of questions. And before we delve into the slides, I want to try to get you guys to, I want to gauge really your who the audience is out there and what your interests are with respect to the topics. So if you guys can just take a minute maybe and answer some of these questions, so we know kind of who's out there and kind of really what topics you guys are interested in. That'd be kind of helpful. So it'd be good to see kind of what everybody's interested in, maybe adjust our schedule accordingly. So I'll leave this open for the next 30 seconds or so and give you guys a whole minute to be able to vote to see what we have out there. So let's see here. Looks like a lot of business owners out there, and a lot of people looking at financing and employment so far. So let's see here. A few more votes coming in. All right, I think it's pretty good. I don't see too many more votes coming in. So, all right. Let me just share the results with you guys here. So here we go. We have quite a few business owners there, some advisors. Financing seems to be the winner in terms of topics, as well as kind of employment law being a close second. So, all right, very good. Thanks everybody for that. All right, so our first topic then, the financing options, and we kind of just broke it up into governmental programs as well as a quick discussion on alternative financing. So with respect to the federal programs, we've all heard, I think by now, about the Paycheck Protection Program. That first link there is a link to our article kind of summarizing the topic. And then the second link is the SBA's website regarding it. As of April 17th, and so far at least, the SBA has dispersed all of its funds in the PPP program, but some breaking news. I think there's a deal that's been reached. Congress is set to vote on it. I believe 3 p.m. our time. So, and if what I've read at least today and been watching CNN is $310 billion has been allocated additional funds into the PPP program. So I think that's very helpful. And what I really want to kind of spend time on is really for those who maybe already have a PPP loan, is just, kind of to emphasize the forgiveness aspect of it. And so if you use your
Steve, can I jump in real quick?
Yeah, go ahead.
So I look at this as two components. The first is the loan amount, and then the second component, of course, is the forgiveness. I'll let you speak to the forgiveness. As far as the loan amount, it's 2.5 times your average monthly payroll. And what a lot of lenders are doing, they're looking at your 2019 activity. So anybody who's looking to jump in and participate in this program, I would recommend that you look at 2019, gather your profit and loss statement for that year, gather all your payroll records, your employment tax returns, gather all those records, and you have to first determine what is your average monthly payroll expense. And then the other part of it, you have to carve out a portion of compensation for any of your employees who make over $100,000 a year. So those are, the first component is the loan amount, and then the second component, once you're successful with the loan, the goal is to try to make sure that it's forgiven, and that's where you get in the second phase. Steve, go ahead and take away from there.
All right. So thanks, Ted. So if for the forgiveness, if you use your if you spend the funds on eligible expenses over the 8 weeks following the loan origination date, then the loan becomes essentially a grant, and it's forgiven. So I list the categories of the eligible expenses there. Payroll, that would be wages, anything up to $100,000 per year, commissions, vacation, sick leave, health insurance, 401k, all those are eligible payroll expenses. Also mortgage interest, at least the interest component of your mortgage loan, and rent. And it's important, because this has come up already for some of my clients, that that mortgage, those loan documents or that lease has to be dated before February 15th, 2020. Otherwise, it's not eligible. Same with utilities. Those utilities have to be in place before February 15th, 2020 in order for them to be eligible as well.
Let me jump in real quick, Steve, on the forgiveness. Right now, we're still awaiting some direction from the SBA and the lenders as to the process of demonstrating your forgiveness. There's going to be an application that's going to be prepared. You're going to be required to gather your record, your substantiation, so you can demonstrate that the loan proceeds was used for these particular reasons. And I think from a small business standpoint, that's the ideal position to be in, is try to demonstrate as much as you can that this is it was used in a proper way so it can be forgiven. Now, the loan amount, if for some reason it's not forgiven, the interest rate is only 1%. So it's still a really good deal if it's not forgiven. Now, the other thing I would add, I've been seeing in the first go around of this program, a lot of borrowers were having a hard time getting through because a lot of the lenders were focusing on their existing clients. And so now that it appears it's going to be refunded, replenished here in a little bit, I would encourage anybody else out there right now who's interested in this to start today contacting a borrower or lender, start that process. Even though it hasn't been fully replenished at this point, I think it will be eventually, if not today or tomorrow, by the end of this week. You want to start that process right away. Find out what those lenders are going to require. Some of you may, if you don't have a relationship with them right now, you may need to go and get your articles of incorporation, a lot of your corporate records. But any business out there who's thinking about taking advantage of this, you got to start that process today as soon as possible, because it will be very popular again, and it probably will run out again, and you don't want to be left out again at this point.
Great, thanks, Ted. Just a quick reminder too, the Q&A is active, the question and answer box, so go ahead and type your questions in, and then like I said, we'll try to reserve time at the end to answer these questions. All right, moving on. The other popular program with the federal government is the SBA Economic Injury Disaster Loans, and there's a related advance with respect to that. That as well has run out of funds, at least as of now. I believe the deal that's been struck with Congress is another $60 billion to be allocated to this program. Unlike the PPP loan, which is forgivable or can be forgivable, this is really a true loan. It covers most operating expenses, and there's underwriting involved. There's collateral involved for loans in excess of $25,000, and borrowers must really not have any other source of credit. If they don't, then the interest rate is 3.75%, and the term can be up to 30 years. But the important thing to remember is this is really a true loan and not something that could be forgiven. All right, and then here in this slide, I wanted to list just some of the more popular, I think, state and local programs that I've seen out there. So these are links you can click on or access. So the Chicago Small Business Resiliency Fund, fewer than 50 employees. Those are the specs there that you have to meet. There's a hospitality program for bars, restaurants, and hotels. And then $50,000 loan at 3% interest over 5 years for the Illinois Small Business Emergency Loan Fund. And if you guys are having trouble accessing the links, this seminar is being recorded, so we'll post it on our website, and you'll have access that way. Or if you want the slide deck, you can just email me. We'll have our email addresses posted at the end, and so just email any of us, and we'll get you a copy of the slide deck if you want it that way. So, all right, some other alternative financing programs or things to consider aside from the government programs is subordinated debt. And here, you have to be careful, because if you already have an existing lending relationship in place, you want to check your loan documents, make sure that obtaining another loan doesn't violate any sort of loan covenants. But if you don't have that restriction, then certainly you can talk to your existing lender or another lender with respect to some additional debt. Another option too would be factoring your accounts receivable as a way to raise additional liquidity. If you need any referrals to factors, we can provide you with those. All right, next topic, deferring payments and fending off creditors. A lot of people, business owners, are in the process now with dealing with this. And so we're kind of tackling it 3 ways here for the purposes of our webinar. We'll talk a little bit about contract issues generally, then kind of landlords and lenders. So with respect to contract issues, what we're dealing with really is kind of the time and manner of performance aspects of the agreement. And one of the things that we see is as force majeure clauses that should be examined, as well as a doctrine called frustration of purpose. So let's just kind of take those in turn. And panelists, feel free to jump in if you have any insights on any of these contract issues as you've come across them. Force majeure, what we're dealing with here, is really kind of an acts of God clause, as it's otherwise known, which could excuse performance by a party or permit an extension of time to perform by that party. And really here, it really comes down to the precise language of force majeure and what it really says. There's lawsuits being initiated, as we speak, with respect to a lot of restaurants suing their insurers with respect to the scope of this clause and whether there's coverage with respect to their business insurance. So it really comes down to what your contract, what your agreement really says. Panelists, you guys have anything to add on force majeure?
No, it's just very specific as to the agreement. Every lease will probably be different in terms of how it describes what events are covered. So that's the big thing that the courts look at for enforceability is this a type of incident that is specifically covered in the lease? And if so, then you may have protection. If not, you have a more difficult argument. Probably the critical ones that you're looking for here, you may see something along the lines of an epidemic or pandemic in the force majeure clause. That's not real likely. It's never really been a problem prior to now. The other one that might be in there is some sort of governmental action. That might be a hook into where you could invoke that clause because obviously the government has shut everything down.
Sounds good. Frustration of purpose. This is a doctrine that exists in Illinois law, and it's essentially a contract defense for a breaching party. Courts have held that it's not really liberally applied. It's a very tough test to satisfy, but there's two aspects to it. First, the frustrating event was not reasonably foreseeable. I think with respect to COVID-19, that's probably the case, at least for actions certainly before probably February, and contracts originating before February. And the second part of the test, though, it might be a little bit more difficult. And again, this is all kind of a facts and circumstances analysis with respect to each contract and situation. But the second part of the test is whether the value of counter performance has been totally or nearly destroyed by the frustrating cause. So here, it could be a tough sell if the coronavirus is completely preventing your performance. And so again, we would look to the governor's shutdown orders and look to other things that are out there that could satisfy this test. Panelists, anything to add?
No, I mean, just as you referenced, this is a really uphill battle in litigation. This is a very rarely invoked method of trying to excuse somebody's performance under an agreement. It's generally a very uphill battle, particularly the part about the party's performance being destroyed. In this case, since there's really no timeline for any of this, if you have a longer term lease, the odds are good that you're not going to be able to invoke this. Whereas if you had maybe 2 months left on your lease, you might be able to invoke it. So the length you have on your lease is certainly going to be an issue anytime you start talking about the commercial frustration.
Very good. And again, if you have any questions on any of this stuff, go ahead and pop them into Q&A, and we will try to get to them either responding by typing, or we'll try to get to them towards the end. So, all right, moving on. Let's talk about landlords and trying to deal with them. It seems to me that landlords are almost really de facto kind of business partners with their tenants, right? Because absent maybe a guarantee in the lease, if tenants stop paying them, and then the landlords have to go and cry court, to their lenders, so they're kind of stuck in the middle. And it makes a lot of sense, I think, for landlords to really try to work with their tenants and try to do some of these things that we have listed up here, lease amendments and restructuring rent payments. Because if their tenants stop paying and the tenant goes bankrupt or dissolves, then all the landlords are really left with is an unsecured claim really for the lost rent. So I think especially now, it's landlords really should really try to partner and find a way to work with their tenants and unfortunately their lenders as well, since they're kind of stuck in the middle, like I said. Lease amendments, that's just a way of documenting changes to the lease with respect to changes in rent or different things. But really the focus, I think, would be on restructuring the rent payments. I've heard of lenders maybe forgiving a month or two of rent, not as likely as maybe restructuring the rent with respect to backloading it, so adding on the rent towards the end of the term, or maybe even re-amortizing it, which means just taking the rent for a month or two and then allocating it over the remaining term of the lease, so that the rent payments for future months go up a little bit more, so that maybe a month or two of rent is not paid right now, but then it's just allocated over the remaining term of the lease. So these are some different things that you should really explore with your landlord. If you're a tenant, then if you're a landlord, you'll have to have conversations with tenants as well as lenders with respect to your portfolio. And especially for landlords I know who have retail portfolios right now versus commercial office tenants, for example. The retail side is definitely getting hit hard. So let's see here.
One thing to add on that, Steve, is particularly as it relates to landlords and their tenants, is the incentive for the landlord right now is you can still file a lawsuit to evict somebody, but unfortunately, you're not going to be able to actually evict them for some time. They're stopped all eviction orders right now, so the sheriff will not enforce them until at some unknown point in the future, at which point they will be backlogged. So you may evict somebody and be successful tomorrow, and they may still be in there in August or September, which would seem to suggest it might be better to negotiate with them and try and figure something out rather than just jumping right to the eviction.
For sure. Lance, can you talk a little bit about the what the status of the courts is and when do you think they'll reopen and how long they're shut down for right now?
Well, they haven't really set an open date for the courts yet. In Cook County, which is probably where I'm seeing the most delay, most of the cases that I've had down there got moved to June, and now I'm seeing dates in July. So you're looking at least probably another 2 to 3 month hold over there. The other collar counties have not come out with revised orders yet. I expect those to get moved back at least a month. Federal court, you can do some of it by phone. Some of the collar county courts are also doing things by phone, so it's not a complete stoppage in those areas. Cook's the real problem. That's not going to get back and up and running for a while. The other ones, though, are kind of hit or miss. I've had judges actually issue opinions while they were at home. So it's just kind of depends who the judge is and where your case is. My thought is I think a lot of the collar counties will start seeing some things open up the middle of next month, May. Cook, I don't expect to see them back on a regular schedule until middle of June, possibly early July.
All right, thanks for the update. All right, in dealing with lenders, if you're a borrower and you have an existing, say, line of credit and you have some availability on that line of credit, a good way to raise your liquidity would be to draw down on that line, especially before, maybe the end of the month when there could be some covenant testing or financial reporting that's due at the end of the month. And so if there's, if you're not currently in a default situation, I see a lot of borrowers that are taking advantage of their existing lines and drawing down the lines to raise cash and have some of that liquidity for expenses coming up, whether lease payments or what have you. Another thing to do is try to be proactive if you're a borrower in reaching out to your lender. Lenders, I think, are can be reasonable with respect to trying to come to some sort of accommodation with you. We've been involved with a variety of loan amendments and forbearance agreements already on behalf of lenders. And so, I think there is perhaps more than ever before, maybe a chance for your lender to be kind of reasonable. And certainly the Fed has encouraged banks to be proactive with respect to lending and their kind of controls over the flow of funds. And so I think it makes a lot of sense if you anticipate if you have these issues coming up with a lender that you explore that possibility with your lender and be proactive about it and not wait for a demand letter or a default letter from the lender. Okay. We'll now turn to the Small Business Bankruptcy and the Small Business Reorganization Act of 2019. These are some new provisions that were implemented, I think, right before Corona hit, and these could be a huge benefit for businesses who really kind of don't see a way out of the current crisis, the current pandemic. So, Ted, why don't you go ahead and take it away?
Yeah, this came out in February of this year. So before we jump into this, I just want to make it very clear. Today, we're not going to talk about individual bankruptcies. We're going to focus on business bankruptcies, and in particular, small businesses. And first, I want to kind of go over the bankruptcy process, give you an overview so everybody is on the same page. When we start talking about bankruptcies, we throw them into one of two different categories. We have a liquidation or a Chapter 7 or we have a reorganization, which is Chapter 11. Now, Chapter 7 liquidation, what we're talking about there is an ending of the business. The business no longer exists upon the filing of that bankruptcy petition. At that point, the bankruptcy court will appoint a trustee. It is a trustee's job to liquidate the assets of the company, send notice to the creditors, and then distribute those cash proceeds pro rata to those creditors who filed claims. The business no longer exists, it ends and it's over with. That's a liquidation. A reorganization, on the other hand, the business will continue. The business is going to continue to operate, but what you're going to do is you're going to reorganize your debt structure. You're going to stretch some of your outstanding liabilities over a longer period of time. It gives you a breather. It gives you time to kind of restructure, but it keeps your business operating, keep your business alive. Now, the problem with Chapter 11 and small businesses was it just really wasn't practical. To file a Chapter 11 bankruptcy reorganization, it became very costly. And I know it's kind of hard to understand. You're thinking, okay, well, wait a second. You're saying it's expensive and costly to do a bankruptcy. If I had the cash to do the bankruptcy, I wouldn't file it in the first place. I would just use the cash for my creditors. So it became very strange for these Chapter 11s and telling potential debtors that, Chapter 11 is not for you because you don't have enough cash. Chapter 11s were largely used by larger, bigger corporations, big companies, and they were out of reach from the typical small business. That all changed with the Small Business Reorganization Act of 2019, and then just past February. So they created Subchapter 5. And that's a great opportunity for smaller businesses to kind of get into this reorganization. So who qualifies under Subchapter 5? Well, first of all, it's only for those businesses that have a commercial or business activity. So what that means, if you're just a real estate holding company, you would not qualify for Subchapter 5. Second of all, there's a debt limitation. Now, when it was first passed and enacted, the debt limitation was $2.7 million. Since coronavirus and the outbreak, they amended that and they increased that temporarily. It's only for another year, but they raised that debt limit up to $7.5 million. So any small businesses out there that fit underneath that $7.5 million debt limitation, you could proceed under Subchapter 5. And then the last requirement, and this is sometimes overlooked, is that you have to have a viable business. You have to have a product or service that you market, that you sell, and that you can do that for a profit, that you have customers that want that product or want that service, and you have to be able to do it for a profit. If you have a product that nobody wants, or you can't produce it at a cost that enables you to profit, a reorganization is not really going to help you. It's not for you. So one of the other benefits of Subchapter 5, it just streamlines the whole process. It makes it easier. There's no longer the requirement of a creditors committee. With the Chapter 11, a creditors committee was required, and actually the debtor was required to pay for the attorneys for that creditors committee. That's no longer a requirement. In addition, ongoing U.S. trustee fees, that has been reduced. You don't have to worry about ongoing trustee fees. The reporting requirements are lessened. It's a smoother, quicker, more efficient process. All that means it's less costly, and that's what brings it into the area where smaller businesses can handle. So what are some of the benefits or strategic uses of a Subchapter 5? Well, let me give you kind of a scenario so you understand how this would work. So let's say you have a profitable business. You're selling a product or a good for a profit. You're making money. You're successful. Everything's going fine. But then unexpectedly, some adverse action takes place. Maybe you have a customer or a client that doesn't pay a bill, or they go out of business, and you're expecting that, and now you without that customer paying, you have a cash flow problem. Or coronavirus hits, and your business is forced to shut down, and so as a result, you have no revenue come in. So what happens in that situation? Well, obviously, You're going to be faced with creditors coming after you. You're going to have lawsuits. A landlord may decide they want to take eviction notice. You may have the IRS start garnishing wages or levying your bank account. Vendors could be suing you. A reorganization gives the opportunity, upon filing of that bankruptcy, you're going to create an automatic stay, and that automatic stay is going to put a stop to all that action, all that creditor action. And when you file the bankruptcy, what you do, you basically divide your liabilities into two different categories. You have the pre-filing category, you have the post-filing category. So any of those liabilities that were in existence upon the filing, those liabilities can be categorized and grouped together, and then you could put them in a Chapter 11, Subchapter 5 bankruptcy plan, and you stretch the payments for them over a 3 to 5 year period. Any post-bankruptcy liabilities, you would pay that as you go, like any normal business. So really what the bankruptcy, the reorganization does, it's going to give you breathing room. It's going to give you an opportunity to take a breath. It's going to keep your business alive. It's going to take those creditors that are coming after you. It's going to force upon them a payment plan, a payment 3 to 5 years. So it just gives you time to keep your business. And it saves your business. It keeps you alive. Okay, so that being said, let's talk about some of the strategic uses. First of all, commercial leases. One of the tools that you have when you file a bankruptcy is that you have the right to reject executory contracts. A commercial lease is an executory contract. That's a contract that still is still being operated upon. So as a debtor, that gives you a valuable tool. Maybe you're stuck with an unfavorable lease. Maybe the rental amount is above market. Maybe the lease covers too much square footage, more space than you need. With the filing of a reorganization, you have a tool where you could reject that commercial lease. Now, of course, if you do that, the business should be prepared to find another location. In addition, you have to factor in if there's a personal guarantee. So if you're a debtor in a reorganization bankruptcy and you choose to reject that lease, that landlord still may have recourse against the personal guarantee. So again, a business bankruptcy filing doesn't protect any claims against the individual owners. But the key takeaway here, though, is that right to reject the lease gives you a lot of power to force that landlord to come back, sit down with you, and renegotiate. Because you put yourself in the shoes of the landlord. They don't want to have a vacant space. They'd rather have a tenant. You're already in there with possession, and the last thing the landlord wants is for you to move out and have a vacant spot. So that landlord is going to be motivated to come in and sit down with you and renegotiate. It gives you the ability to perhaps reduce that monthly rental amount. So that's just a valuable tool. Tax liabilities, let's talk about that. A lot of times what happens when businesses start having cash flow problems, sometimes they hold back and don't pay their employment taxes. And eventually the IRS will catch up with you. They will start levying your bank account. And when they start levying your bank account, it's very difficult to operate your business when you're trying to pay payroll, the cash is seized by the IRS. So the reorganization creates an automatic stay, puts a stop to that levy action, and then you could pay off that tax liability over a 3 or 5 year period. It just gives you more time. Vendor debt, let's talk about that real quick. Vendor debt is ordinarily unsecured debt. And in a reorganization, you have a possibility where you could probably squeeze down the amount of their claim. Maybe instead of paying them 100%, you could probably force down a lesser or smaller percentage of what they're due. Now, keep in mind, if you're going to try to do that, if you need that vendor in the future, let's say they're a key supplier for you, you're probably not going to want to try to squeeze down their claim because they're not going to want to do business with you post filing. So, but it does give you that opportunity if that becomes something that you need to do. So, the takeaway with this reorganization, it just provides this reorganization bankruptcy to smaller businesses. It makes that available for them. It just gives you a valuable tool. If you have a viable business, a business that can be successful, but you just need some time. You need to take a breath. This small business reorganization provides you with that opportunity. It gives you time. It saves your business, but it gives you time to get caught up on that arrearage or delinquent liabilities.
All right. Panelists, anything to add on bankruptcy, small business bankruptcy? No? Okay. All right, we'll move on to employment law issues. I know some of you, I believe that was the second highest ranked topic in our poll. So who wants to go first here?
I can speak to some of these. So obviously with everything going on, employers and employees across the board are dealing with all kinds of issues. We picked a few of the topics that we're getting the most questions about to speak to those a little bit today. Specifically, we're going to talk about staff reductions, reducing payroll, reducing staff, how to do it the right way, the expanded sick and family leave requirements of the FFCRA, which Congress recently passed, the expansion of unemployment benefits under the CARES Act, which Congress also recently passed, and then in the case of an employee who is infected with the coronavirus, how to communicate that to your other employees in the best way. So the first topic is staff reductions, pay reductions. The question that I am getting, I think all of us are getting from a lot of clients, a lot of business owners, is what should we do to reduce staff? What should we do to reduce payroll? And the two things you're always hearing about are layoffs and furloughs. And I think it's important first to understand the difference between a furlough and a layoff. A layoff, simply put, is a termination of employment. So when you lay off an employee, they are no longer an employee of your company. That employment relationship is ended. On the other hand, a furlough is not a termination of employment, but is more of a temporary suspension of work with the intent that that employee is going to be restored to their full position when things turn around. So with the layoff, you're cutting off employment completely. With the furlough, you're kind of just putting somebody on the bench and expecting to bring them back in the future. So now a lot of employers will say, okay, what's best for my situation? One thing to keep in mind is that there are different costs associated with furloughs and layoffs. With layoffs, because you are terminating somebody's employment, you got to keep in mind that when that relationship ends under Illinois law, you got to pay out their unused vacation. The same does not go for furloughs because, again, there's no termination of employment. So from that perspective, a layoff may be less expensive for the employer, but there's also risks to it, especially when you're dealing with salary employees. Now, with hourly employees, a furlough can be kind of an easy process. They're only paid as much as they work. So if you take them off the clock, if you take them off the schedule, then you don't have to pay them as much. With salary employees, they're supposed to be paid a full week's salary, whether they work 1 hour or whether they work 80 hours or anything in between. So what you don't want to do is furlough a salaried employee, tell them to stop working, and then find out they're putting in some work, and now they have an argument that you should be paying them for the full week of work. So there's some risk there with furloughing salaried employees that things might happen that require you to still pay them in full. So if you are furloughing a salary employee, it's important to communicate to them they're not to be working at all. Also, the way that overtime laws work, there's a lot of changes, constant changes in a salaried employee's salary. They may lose their exemption from overtime. So if you're furloughing an employee 1 week and then bringing them back the next, and then 2 weeks later you're reducing their pay, they might have an argument that, hey, I'm no longer a salaried employee. I'm an hourly worker, and any week I work more than 40 hours, I should be entitled to overtime, which obviously is a huge problem because you're trying to reduce pay, and all of a sudden you might create more pay obligations for yourself. So I think at the end of the day, a layoff is a little bit cleaner and less risky. A furlough can be less expensive. You just got to make sure you're doing it the right way. So I think it's important to consult your attorney when you're communicating those types of things to your employees. I also want to talk a little bit about the WARN Act. Now, a lot of employers might not be totally familiar with the WARN Act. There's the federal version and an Illinois version. The Illinois version is more applicable because it applies to smaller businesses than the federal version does. The Illinois version only applies to employers with more than 75 full-time employees. So with that, it may not apply to many of you. But if it does apply to you, it's important to comply with it. And what the Illinois WARN Act says is when you are going to have a mass layoff or a plant closing, and those are defined terms under the statute, but essentially when you're looking to lay off many employees or do sweeping reductions in pay, you have to give your employees at least 60 days advance notice. So if you want to fire somebody sick, or if you want to do a mass layoff 60 days from now, you need to tell the employees now that you're going to do it. And if you don't do it, it's costly, because in addition to getting hit with certain civil fines, you can be required to pay out the employees for that whole notice period that you did not provide. If you only give them 30 days notice and you should have given them 60, now you can be forced to pay them 30 extra days worth of wages. So it's obviously important to make sure you comply with it and not to expose yourself to additional payroll liabilities. The good news is there's exceptions built into the WARN Act for unforeseen business circumstances and natural disasters. I think a lot of employers subject to the WARN Act would probably say the coronavirus is either or both an unforeseen business circumstance or a natural disaster, meaning we don't have to provide that advanced 60 days notice. That's a little bit of an unsettled area of law. I would be surprised if the law came down against employers on that, but we don't know for sure. So long story short, if you have more than 75 employees and there is going to be some sort of mass layoff, just be careful how you do it. Again, I would consult with your attorney to make sure you're doing all the right things. Moving on to the next topic, we wanted to discuss the new sick leave and expanded family and medical leave under the Families First Coronavirus Response Act. This was kind of the first big piece of legislation you saw Congress enact when this all started happening. One thing to keep in mind, it only applies to employers with less than 500 employees, which I'm guessing is most of our audience today, but if you have more employees than that, you don't have to be concerned with these, but really these are looking to give benefits to employees who either are out sick due to coronavirus, they are under a mandatory stay-at-home order by the government or maybe by their physician, they are home caring for a family member who is sick with the coronavirus, they are home caring for a child who is off of school because of the school closures that are going on, all those types of circumstances. And like I said, there's two different benefits that were put in place by this act. The first is the paid sick leave, which says that under those types of circumstances, employees are entitled to up to 14 days or 80 hours of paid time off. It's important to note that that's 80 hours of paid sick leave in addition to what you already have provided your employees. So even if you already have a PTO policy, a sick leave policy, a vacation policy, this is 80 new hours that the employee gets. You can't require them to use that PTO or that existing vacation time first. At the same time, the Act expanded family medical leave under FMLA, the Family Medical Leave Act. Normally, the FMLA only applies to employers that have 50 or more employees. For purposes of the coronavirus, that threshold is now gone. This expanded FMLA leave applies to all employers with less than 500 employees. And what it says is similar to the FMLA. If somebody is suffering those types of circumstances we discussed, they are entitled to take 12 weeks off of work, and you must protect their position. You can't terminate them because they're exercising their right to take leave due to the virus. You have to restore them to their position when they come off of that leave. One difference between this and standard FMLA leave is that after the first 2 weeks of leave, the last 10 weeks of leave are paid. Now they're paid up to a certain amount. I think employees are able to get up to 2/3 of their regular pay. But what that means is essentially an employee who's dealing with one of those types of issues can take 12 weeks off of work. The first 2 weeks can be paid as that 80 hours of sick leave. And the last 10 weeks can be paid under this new FMLA expansion. And while that's going on, you can't terminate them unless there's some sort of legitimate business reason to do so other than the fact that they're out sick because of the virus.
Josh, real quick, if an employer does have an employee that fits these requirements and an employee does want to take advantage of this leave, can you kind of comment of the employer's right to kind of make themselves whole through employment tax credits?
Yeah, that was one of the notes I was getting to. Employers are eligible for 100% reimbursement of the benefits they're paying out under these new benefits through a tax credit. So if you do have employees going through the situation, it's definitely important to sit down with your CPA to make sure you're taking full advantage of those credits. I believe those come in the form of credits against your 941 payroll tax obligations. So keep that in mind.
One other question, Josh, or Lance for that matter. I've been hearing questions from clients who have employees that do not fit within the family's FERC requirement. You know, they're not COVID positive, or they don't have a family member COVID positive. However, they're not comfortable coming to work. They're afraid. Maybe they'd rather work home, and sometimes employers, it's the nature of their position, they can't work at home. Can you comment on what an employer's obligation would be in that situation?
Well, if we're working from the position that they're not entitled to that sick leave, they're not entitled to the expanded FMLA leave, then it really comes down to what the employer's general policies are. Maybe they could take paid vacation. Maybe there's some other form of paid sick leave they could take. Of course, if there is an ability to work remotely, I think employers should be giving employees the ability to do so, or finding them some sort of comparable position where they can do so. If that's not a possibility, then they could always take unpaid leave. It could be a furlough situation like we were talking about before, but I mean, technically they're an at-will employee, so it's more or less up to the employer how they're going to handle that situation, assuming they're not covered by the FFCRA that we just talked about.
Okay.
And one other thing I did want to note on that end, a lot of business owners have been asking me, if my business is shut down due to the governor's ongoing shelter-in-place orders, am I still required to pay out sick employees under this new law? And that was unsettled for a while, but guidance was finally issued that if the workplace is shut down, if the workplace is not operating, you're not required to pay sick leave to your sick employees. You're not required to pay employees who would otherwise be exercising this expanded FMLA leave. They do get paid up until the date that business closes, but once business closes down, these obligations go away until you open back up, which is obviously good news for employers. The next topic that I wanted to hit on was the expansion of unemployment under the recently passed CARES Act, which was the second piece of big legislation that Congress passed to deal with the virus. And there are two big things to discuss there. This really benefits employees more than employers, but it's something to keep your employees aware of. First, they greatly expanded eligibility for unemployment benefits. Normally, only W-2 employees are eligible for unemployment, and they're only eligible for unemployment for a specific amount of time. For people who are dealing with coronavirus-related issues, like the kind that we discussed, it's now available, in addition to W-2 employees, unemployment is available to self-employed individuals. It's available to those with a limited work history, which because of that, they normally would not qualify for unemployment, or those who have already exhausted their unemployment benefits. So it obviously broadens the pool of people who now are eligible to receive unemployment. Second, it substantially increased the unemployment benefits that are available. Unemployment benefits were increased by $600 a week. That lasts through July 31st. And also that law provided for an additional 13 weeks of unemployment benefits. So obviously some pretty substantial benefits to employees who are out of work for one reason or another in relation to the virus. So if you are laying off or furloughing workers even, I think it's good to communicate to them that they should definitely be talking to the Illinois Department of Employment Security, seeing what benefits they're available for, and in applying for these benefits to kind of bridge the gap until they can find new work. The last topic that we wanted to hit on is how to communicate with employees when you find out that an employee has been infected with the virus. As far as employer obligations under federal law, employers do have a general duty to maintain a safe workplace. And generally that's interpreted to mean that you have to advise your employees if they have potential exposure to the coronavirus. This comes into play where you determine that an employee who's been in the workplace has tested positive, they're infected, they may be infected. In that case, the question is, how do we deal with this? How do we communicate that to other employees while also protecting the infected employee's privacy? It is important and most likely an obligation to tell your other employees that there is a risk of exposure due to the fact that one of your employees has been infected. But the catch is, you can't expose that infected employee's private confidential medical information. If you, for example, if you tell your workforce that a certain person was infected and because of that they're exposed, that's a violation of federal law and you could get yourself in trouble. So kind of a middle ground to do that is A, to tell your workforce, hey, an employee has been exposed, they've been in the workplace. You might want to think about trying to get a test or quarantining or doing whatever you think is best. Especially if you find out that that employee has been in contact with certain employees, it's important to tell those employees specifically that somebody has tested positive and we know that you were in contact with them. So we need to talk about how we're going to deal with that. We would advise you to advise your employee who is infected that he or she should be telling his or her coworkers what the situation is. You can't force them to do so, but it would be great if they would do that, because obviously the more information your employees have, the better. And maybe he or she would consent to you giving his information out, letting the other employees know that that person was infected, so employees can realize their potential for exposure and can make the best decision for their situation. That's all I have on that topic. I don't know if anybody else has anything to add.
No.
All right.
All right, so let's get to some questions. We've been, I think, doing a good job of keeping up here on the Q&A, answering a lot of your questions.
One question I did have for Ted, sorry to cut you off. We were talking about those paycheck protection loans. Are those taxable? Does that constitute taxable income if you receive a loan?
That's a good question. I mean, the general rule under tax law is anytime you borrow money and that loan is forgiven, generally that amount of the loan that is forgiven is recognized as taxable income. But in this situation, under the PPP loan program, there's an explicit provision that provides that any forgiveness is not taxable. Now, the other question I'm still struggling with, I'm still waiting for guidance, gets to the deductibility of the wages that you pay out. That's where it gets a little bit more interesting. So I mean, so yeah, the fact that the loan was forgiven, you use the loan for payroll costs, that loan is not recognizable as taxable income. But then, are we able to deduct those wages as an expense as you normally would? So I'm very curious to see how that plays out. I'm anticipating that there may be some provision that would also, indicate that those payroll costs that you use a loan for would not be deductible. But I'm waiting to see on that.
Yeah, that would seem odd if you have, it's kind of a little bit of a windfall for the taxpayer, right? If you're allowed a deduction for tax purposes without the corresponding kind of income item.
I mean, I think the way they view it is it's essentially a non-event. You're almost a conduit. I mean, the loan comes in from the SBA, and if the employer uses it for payroll costs, it's not recognizable as income, but it would just go to show that you also don't deduct it. It's almost like a non-event. But again, I haven't seen any specific language or guidance from the SBA on how to treat those payroll costs as far as deductions are concerned.
Good. Any other questions? I don't see anything open in the Q&A. Here's one.
Hey, I have a question for Josh or Lance, dealing with the obligation of an employer to provide a safety environment. I mean, you go into grocery stores and you typically see, all their employees wearing masks and gloves, and you have guards put up that interrupts the interaction between the customer and the clerk. I mean, what's your recommendation on employers in maintaining a safe working environment? What are you telling your clients?
Lance, you want to take a stab at that?
I don't know that there's any specific requirement for it in terms of being safer. I mean, you have an OSHA concern maybe, but that's more not going to be related to this, I don't think. I think certainly now in grocery stores and places like that might be a little bit stricter requirement you want to deal with there just because of the nature of what you're doing. But imagine a lot of food industry type places also would probably want something stricter, and they may in fact have OSHA guidelines that have come down that we haven't seen that do address all of that. But I mean, as a general practice, just if you're talking about service type business outside of grocery or food or something along those lines, I think you're a little bit left on your own and you don't have any specific requirement.
And it may also depend on if if you're aware of an exposure to COVID. I mean, certainly as an employer, you probably want to take some steps to sanitize the working area, or if it's a common area, I think the employer it would be prudent for them to take some of those steps.
Right.
All right, looks like we don't have any other open questions at the moment. Do the panelists have anything for each other? We did put up the slide here for our contact information. Feel free to reach out after the program. You can email us or give us a call, whatever you want to do. You guys have anything else you want to talk about?
The only things I'd add to when Josh was talking about furlough would be, for unemployment purposes, a furloughed person is unemployed. The differential that the Illinois Department of Employment Security has drawn between a furloughed employee and a terminated employee is, normally when you're terminated from your job, you have a requirement to be looking for work after that. And part of your unemployment benefit and receiving it hinges on that. If you're furloughed, however, they've changed that for coronavirus purposes to say that you don't need to be looking for a job. So you don't need to register to be looking for work. The understanding is at some future date, you're going to be going back. And then Josh also addressed final pay if you do terminate somebody. One of the big ones that I'm seeing or run into issues with is not just the vacation days, but commissions. Commissions become final compensation at the end. They're due when earned. So if you're letting go of a salesperson that has earned, however that might be defined within your particular company, their commissions at that time, you have to shell out all that money as well.
All right. I'm going to put up those slides back here where we have some links for some funding or government programs. Just keep them up a little bit longer for people, especially the state and local ones there, for a few minutes at least, so people can check them out or whatever they want to do. Because I don't know if they click on them, I don't know if it would actually take them to the website or not. But again, if you guys want to, a copy of the slide deck, just reach out and we can send that along.
Yeah, maybe I can piggyback. One of the questions one of the attendees was asking about, should they use a big bank? Should they use a small bank? I do know this latest go around, there was a lot of talk about allocating a portion towards smaller community banks. And I think if you're a small business and you're banking with a Chase or a Bank of America, it's easy to see how you may get lost in the shuffle of all the other larger customers of theirs. Using a community bank, I think, makes a lot of sense. Now, that being said, trying to establish a new relationship right now may be challenging. And so, it's a tough situation to be in. And for that reason, I would become very active as soon as this webinar is over and calling, even if you're with Chase or Bank of America, trying to get start working on them as soon as possible. And you got to be, the squeaky wheel gets the oil. You got to be persistent and stay on top of them. There are a number of community banks. I know they're looking at this as opportunities to add new customers, so that could be something that they may be looking to take advantages of, and so reaching out to community banks makes sense as well. So I just think you got to be very proactive and be persistent.
Yeah, I would agree. I saw that too, in terms of an emphasis on getting the new funds at least to smaller banks. Okay. All right. So, anything else? Anybody? Our 1 hour is almost up, so I'm going to try to. One of the attendees suggest putting copying the links over into Q&A. I'm going to try doing that here real quick. So feel free to start talking about anything else you guys want to talk about. I guess I got to try to figure out how to do this real quick. some screen maneuvering.
Yeah, I would just piggyback on what Steve said. I mean, you may have other questions that occur to you at a later date. You have our email information. By all means, don't hesitate. Shoot us an email. Give us a call. You know, we're here. We're eager to help out. But yeah, just don't hesitate to reach out to us.
Yep. All right, so I'm going to try to, I suppose I could use the chat function here. Start pasting some of these links in. That one seemed to work. Okay. Sorry, it's just taking me a while to maneuver through these windows.
There was a question about a client, a customer filing for bankruptcy and the priority for their claim. You know, if your customer filed for a bankruptcy and you are a creditor, then of course you would file a proof of claim. Now, your priority is going to be a function of the nature of your claim. If you're an unsecured creditor, you're going to be treated differently than if you're a secured creditor. If you have a customer that is threatening bankruptcy, you know, they may try to negotiate with you, maybe try to negotiate for more time. One of the strategies you may have would be to try to have them give you a lien and put a lien over their assets. And that would put you in a better position should they file a bankruptcy later on. But if they've already filed a bankruptcy, your priority is going to be determined based upon the nature of your claim, whether you got a lien or not, and the nature of your claim against the company.
Okay. Chat. Where is it at? There we go. And there's the last one there. So check your chat, everybody. All three links that you see right now in that slide are in your chat window. So you should have them all. All right. We have a few open questions, or see. No, I think these are all just comments. All right, I think that should do it. We're at certainly a little over our limit. So again, just to wrap up here, feel free to reach out to any of us if you have any further questions after the program. Thanks again for joining us. We offer free initial consults for any new client, any new matter. So we'll definitely spend the time with you and see if we can assist. Otherwise, have a great day. Thank you all. Thanks, panelists, for attending and participating. I think it was got some good comments already, and it's been very helpful.